Thank you, Mr. Chair. Attorney General, on May 15, 2024, you sent a letter to President Biden recommending he invoke executive privilege on audio recordings of his interview with Special Counsel Robert Hur. In this letter, you claim the precise concern is that executive privilege protects materials related to a closed criminal investigation where disclosure might hamper prosecutorial efforts in future cases. Is that correct? I think you stated that earlier.
Yes.
In this letter, you also wrote that you are concerned about the prospect of committees of Congress obtaining confidential records from Justice Department of criminal investigative files for the purpose of addressing highly politicized issues in public committee hearings. Is that correct as well?
Are you citing my letter?
Yeah, in the letter
that's correct. Yeah.
Right. So let me go back. In the United States versus Mitchell, during the Watergate District Court case, Judge Sirica held that by releasing portions of a subpoenaed recording in transcript form for publication, the president's claim of confidentiality and that privilege associated with it was no longer valid since the conversations were no longer confidential. You produced the transcripts to this committee, correct?
Yes.
And prior to producing the transcripts to the committee, they were leaked to the press. So based on Mitchell, which is still good law, the recordings are, in fact, no longer confidential, aren't they?
Can I respond? I'm sorry, that's not what Mitchell was about at all. Mitchell was, first of all, about transcripts created by President Nixon, for which there was plenty of reason to believe that they were not accurate. And secondly, it had to do with the confidentiality of communications between Nixon and his staff. And once he provided the transcripts, the court said those communications were no longer confidential. That is not the allegation. That is not what we're asserting here. Here we're asserting confidentiality over the audio, not confidentiality, but protection of the audio in a criminal investigation, an interview, not a staff meeting.
Okay, thank you. Let me move on. Your May 15th letter also relies on the argument that producing the audio tapes would affect the department's ability to obtain vital cooperation in high-profile criminal investigations, in particular in investigations where the voluntary cooperation of White House officials is exceedingly important. Is it your testimony that a White House official would voluntarily cooperate in a criminal investigation only if the Justice Department promises not to release the audio recordings? That doesn't make any sense.
The long-time experience of the Justice Department, is also reflected in the declaration that was filed under oath, is that witnesses want to protect the confidentiality of their communications with the prosecutors during these sensitive interviews. In the Cheney case, the Justice Department made the same claim, even with respect to FBI notes about interviews of Mr. Cheney and that special counsel. It's our view that we need witnesses to be willing to be tape recorded or audio recorded, and that they are going to be less willing to do that if they know it's going to be made public. In the declaration that was filed in court on Friday, the senior official stated that he knew of cases right now where people are unwilling to provide audio because they are worried about it becoming public. So the answer is yes, that is our view.
Attorney General, have you listened to the audio recording?
I have not, because there's no reason for me to listen to it in order to make the determinations that I had to make. We had the special counsel describe in detail his explanations for his determinations.
So let me, I don't understand how you can kind of sit before the congressional committee and kind of arbitrate what's indistinguishable from the transcripts if you're not even sure what's on the tapes themselves.
I'm not doing it on my own. I have.
So you're saying other people have listened to it within the department?
Within the department, and the special counsel has listened to it, and the special counsel had every interest in ensuring that the transcript that he produced in order to do his investigation would be accurate. Yes, that's right.
Okay, so let's go back. So in May 15th letter, you also attempt to distinguish the committee's reliance on the United States versus Nixon. Specifically, you claim that since President Nixon had released only edited transcripts of a portion of the meetings covered by the audio recordings, the Nixon case does not apply. But that was not what the court held regarding the enforceability of the special prosecutor's subpoena, was it? That doesn't match up right now then.
I'm not exactly sure what you're asking. That Nixon, it was well known that Nixon had edited the tapes, had edited the transcripts, and he said he had edited the transcripts. That is not what happened here. The special counsel, the FBI agents in the room, and the senior career official said that the transcripts matched the audio.
So the court reasoned that the audio recordings would be relevant to show, among other things, a criminal conspiracy and for other valid potential evidentiary uses for the same material.
In the Nixon case, yes,
Yes.
because there were parts of the transcript in which the conspiracy was disclosed of those communications, which parts of the audio in which were not in the transcript. That's not the situation here. Here,
We don't know that, though, Attorney General. We're unaware because we haven't heard the tapes. We don't know if they match up.
everyone had a genuine reason to
Time
believe
of the-
that those transcripts were not accurate. Here, you have the special counsel, you have
Time
the
of the
FBI
gentleman.
agents in the room, and you have the senior career official in the department all comparing it and finding them to be accurate.
Time of the gentleman has expired.